This is the appointed time and we have a quorum. So I call to order this meeting. We have the terms of reference proposed, and the Secretariat has prepared for us the draft of the draft terms of reference. So if there are comments, we can discuss the terms of reference now. We don't have many members here, but to uphold the speaking time limit, I'll allow 5 minutes for the first round. Who would like to speak first? Mr. Holden Chow. Thank you, Chairman. Now, on the proposed terms of reference, my comment is this. I think we should accurately reflect the content of the petition submitted by Mr. Kenneth Leung and Mr. Andrew Wen. To accurately reflect the content of the petition, may I suggest that we adopt the content of the petition as the terms of reference. In short, let me read it out. To inquire into the reason why the Chief Executive has not acted in accordance with Article 47 of the Basic Law, in which sets out the declaration declaration of interest system for ex-co members, and whether and to declare the amount received or agreed to provide services for the commercial organization, whether that would cause a conflict of interest for him as the Chief Executive. And I think that this content should be adopted as a terms of reference. So basically, we're going to paraphrase the petition and adopt it as a TOR. Right. Any other comments from members? Mr. Lam Cheuk Ting. My Chairman, just now Mr. Holden Chow said the reason why so and so. Does it mean that we have drawn a conclusion? To inquire why he hasn't. There's something like that. Now please refrain from having a conversation among yourselves, because I think that according to the petition made by Mr. Kenneth Leung and Mr. Andrew Wen, the wording used is whether he has followed this and that. And I think this is an open-end question. I think it's in appendix whether or not he has abided by. Well, please refer to appendix 1. This is the petition. I am looking at the page prepared by the Secretariat, including whether he has acted in accordance with Article this and that of the Basic Law. I think this would be more appropriate. Is that it? Mr. Junis Ho. Well, I'm learning to ask questions. In Appendix 1, I think in terms of the scope of inquiry, how wide it should be. For example, whether there is any contravention of Article 47 of the Basic Law in relation to the duties of the Chief Executive, and as an EXCO member, in relation to the declaration of interest. I think these are the major issues. But when Mr. Kenneth Leung and Mr. Andrew Wen submitted the petition, they also mentioned that there are taxable items in the remuneration stipulated in the agreement. Well, if the objective of the Select Committee is to inquire into whether the Chief Executive has contravened Article 47 of the Basic Law, then as to whether the remuneration is taxable or not, I think this is only secondary issue. So I think the TOR doesn't have to include the part about the taxable remuneration. Can we focus our inquiry on whether the Chief Executive has contravened Article 47 of the Basic Law and whether he has contravened the Declaration of Interest as an EXCO member. Now, to respond to Mr. Junius Ho's question, we're only focusing on the wording to be adopted in the TOR. If you're talking about the actual content, I think that we will be confined by what is set out in the petition if we adopt the petition. So we cannot delete the parts about taxation. I'm trying to learn here, Chairman. I think the question is whether he was acting in any inappropriate manner. So if we have to adopt this petition, which is quite superfluous, I think the focus is still on whether he has contravened Article 47 of the Basic Law. I think what we're concerned is his integrity, not whether the remuneration is taxable or not. Because, say, if it's taxable, well, how would we know whether he has paid tax or not? It's basically out of Hong Kong jurisdiction. So it seems to be a very minor point. Well, just now, Mr. Holden Chow said that we should adopt the wording of this petition. I don't think we should accept that fully. I don't quite agree. I think we should focus on the major issues. That is Article 47 of the Basic Law and Declaration of Interest. Well, we do have three major issues: conflict of interest, taxation, and declaration of interest. So these are just the three major issues, irrespective of their order of importance. All right, I just want to clarify the matters. Well, let's hear from other members first. Mr. Kenneth Lau. Thank you, Chairman. Well, of course, Chairman also read our petition. I don't think we have a major theme and a minor theme. I think it's all about integrity. Now, for the Premier of Iceland in February, he resigned regardless of whether he in fact paid tax or not. So in relation to the acceptance of £4 million of fees, whether or not it's about conflict of interest, declaration of interest, or taxation matters, all these are relevant from the perspective of a third party. Then, as the person submitting the petition, I can give you first-hand, my view first-hand, and that is there is no major or minor issues. Dr. Priscilla Leung. Well, we don't have to be so modest. Whenever Rule 26 is invoked, we must reluctantly accept it. However, if it is really too outrageous, it will give a perception that the Legislative Council is abusing resources. In terms of the TOR, I also think that we should focus on the issues. Well, of course, we can further refine the wording of the petition. But if this is what you want, I also agree that the declaration of interest should be our major concern. As for taxation matters, I think the IRD will follow up on it. I don't mind if we adopt the petition's content. What I mind is fishing expedition. Now, I think if we add words like and relevant matters and relevant issues for the Select Committee, then in our experience, we already have a lot on our plate. And we should avoid giving a perception that we are abusing the system to achieve some political purposes. So I think that we should adopt what is set out in the original petition. Next, Ms. Eunice Yong. I'd also like to comment on the proposed TOR. Now, as Chairman put it just now, we have three major issues. First, whether the declaration requirements have been complied with under Article 47 of the Basic Law, and whether a conflict of interest has arisen as a result of his position as the chief executive or EXCO member, and also taxation matter. So perhaps we should focus on these three issues instead of what is set out in the proposed TOR. Because otherwise the scope would be too wide. And we may need to discuss more than these three major issues. So I'd like to adopt a more precise version. Any other comments from members? Mr. Alvin Young. Chairman, I don't know what the point is. All the discussion. In fact, there are only three major points proposed in the TOR prepared by the Secretariat, and the Select Committee is basing the investigation or inquiry on these three matters. In fact, the person making the petition already set out what he thought just now, and I think it's argument for the sake of argument. And well, unless it's about the wording into relevant matters, and that we're adding other matters to the inquiry. But we're not doing that, so why do we need to discuss at length? We're only focusing on these three issues. I really don't think we need to dwell on the minor points. Well, I think the Secretariat's proposed TOR is that matters relating to so-and-so. Well, as lawyers, when it comes to the actual inquiry, there might be a dispute. Chairman, I think that, in fact, if there are other members who would wish to add to this TOR, we only have 4 members of this sort. So definitely, when any matter is put to a vote, they will not get what they want anyway. Well, let's not impute on other members' motives at the moment. Mr. Kenneth Leung, you'd like to add? Perhaps we can invite the Secretariat to explain the wording. I think the 3 major issues are very clear. But we may have different interpretation of the proposed TOR. So would the Secretary please explain the wording? Well, just now I sort of taken up some of Mr. Wong Kok Heng's time, so I'll allow Mr. Wong Kok Heng to speak first. Mr. Wong Kok Heng, I think I share other members' views, and that is inquire into matters relating to. I think that this could be a controversy. It could become a dispute if any member wishes to add to this TOR. If in the original petition it isn't phrased this way, we should not add these 4 words in the Chinese version. So I think we should take them away to make it more precise. Mr. Junis Ho also raised a point. I agree with him. At the same time, I also agree with Chairman's observation, because we cannot change the content of the petition. The IRD will follow up on the taxation matters. I think that this name, matters relating to, there's a problem with the wording, so I'd like the Secretary to explain that as well.
So before the second round, the Secretariat can elaborate on their drafting. The Secretariat was responsible for drafting the terms of reference, and during drafting, Mr. C.Y. Leung received funds from an Australian company. That was a very large topic, and we wanted to describe the three issues that reflected in the petition. So that's why those 4 Chinese characters were introduced. Yes, I heard that there was some concern into the phrase inquiry into matters and whether it would widen the scope. Now, after discussion with my colleagues, even if we were to delete the terms to inquire into matters, my understanding is that it will not narrow the scope of the investigation. So, if some members feel that they wish to delete to inquire into matters, well, you could consider that, because in our draft we have already considered the 3 issues we want to investigate. Legal advisor? Well, the Secretariat's paper on drafting of the terms of reference, as we explained, it was based on the petition, and of course there has been some editing to the petition. Now, if we look at the term of the petition, we see that the proposed terms of reference has reflected the contents of the petition. So the Chinese term 包括 has been included, and that's why in the drafting of the terms of reference we have the phrase to inquire into matters. Okay. The petitioner has already given his explanation, so let's follow the speaking order. Lam Chartlan. Chairman, referring to the petition, the first paragraph says that the media has reported that in 2011 the chief executive had signed a secret agreement with Australian company UGL and received a payment of £4 million secretly received this payment and would be paid in two phases. And it follows as to say that there are a lot of issues that have not been disclosed, and it reads on as follows. So, and they wish to investigate. So my understanding is that they want to investigate the issues mentioned in the first paragraph, including the second paragraph and the contents therein. So the Secretariat's drafting is appropriate. That is, to include matters, because when we're investigating these matters, it has a context, a contextual referral to the first paragraph. So if we have three issues occurring, and then other matters are related, then I don't see why the Select Committee should not handle it. That's my humble opinion. So perhaps Mr. Kenneth Leung and Mr. Andrew Wan also explain, are they just limited to those three issues? Well, Mr. Andrew Wan, it's his first time to speak, so let's him speak first. Well, Chairman, I don't mind with the editing of the wording. We want to be clear in our purpose, but I am concerned, as Mr. Lam Chartlan said, that this is not something new. In the past, we had different select committees. They had different terms of reference, and their line of thinking, their mode of thinking, well, they would have a name. Now, if I recall, this methodology to inquire into matters. I've read a lot of I've seen this phrase on numerous occasions in the last few months. Now, let me compromise a little bit. So if we delete that, then I think they would lead to some. It would lead to some anomaly. So if we say that we're looking at Mr. C.Y. Leung's agreement with the Australian enterprise UGL, well, that would we are trying to see whether there was any contravention of the law. But now, if that is not included, then what is the object? Then we are looking into the agreement. What is the agreement? So textually, there's some anomaly here, and that might be even worse. Of course, some colleagues mentioned that will we be trying to hang on ornaments onto a Christmas tree? Well, no. Well, Mr. Lam Juk Ting also raised an issue, and this is what we're looking at right now. Will there be other related matters? It might be a very large issue. Does that mean that it's off limits? Are we afraid? Have they heard rumors, or that's why they're so anxious? Well, you know that a lot is happening in the last few months. So in the first half, I think just reading it textually and just considering the logic. So does that mean that in future select committees, do we have to delete the phrase to include to inquire into matters? Well, let's take a look at Annex 2. Since 1997, we had set up 2 select committees. There was one relating to Mr. Timothy Tong, and the other one regarding the express rail link. They were petitions, and so we do have these precedents. So if you look at the English, there's no anomaly. If you can refer both to the Chinese and English to consider the way forward. Next, we have Ms. Priscilla Leung. I think we just want to start work early, and I think there has been argument just for argument's sake. Now, I heard Mr. Zhao Hoding say that he wants to refer to the contents of the petition. Well, in my experience, I have sat on some select committees with powers and privileges. So if there is a related issue, and even if we don't have the phrase to inquire into matters, if it's still within a reasonable scope, you can still investigate. So you don't need to worry that if you scrap the terms inquire into matters, then you would be prohibited from investigating. As I said just now, either you delete related matters, but then you look at Annex 2, it's a description there, it's very accurate, and in fact your petition is sufficient to give us a scope for investigation. So if you have no intent to digress, then I myself, I have no worry. I do have experience that I don't want to see a fishing expedition, and ultimately when you draft a report, there's no focus, there's a lot of argument, and there's a waste of time and resources. Well, if this is a preview, then we know what will happen when the show really starts. Mr. Ho, Junius Ho. Yes, we want to focus. We want to know what the select committee is about to embark on. Now, I referred to a main theme and secondary theme. Now, if we do have a breach of trust, and I referred to the tax being some derivative occurring or an issue arising from the first two. But then I think if we open the Pandora's box, then I think we would have a lot of, we would be sidetracked. So could we phrase it this way? The subject matter to inquire into matters relating to Mr. Leung Zhenying's signing of an agreement with the Australian firm UGL Limited in 2011, UGL agreement, and his receipt of payments amounting to £4 million from UGL Limited in connection with the UGL agreement. We don't need to have the term include matters. We can just say whether the CE : breach Article 47 of the Basic Law, and second, whether there was a conflict of interest in the UGL agreement, and the third, whether payments were taxable under laws of Hong Kong. So we can just highlight these 3 points. There was a receipt of $4 million. Was there a breach of Article 47? Did he breach his need to declare interest, and then whether tax was payable? Now, in their petition, paragraph 2, they say that there have been a lot of issues that have not been clarified, and that will give us that there's a lot of room for a lot of speculation, and if you investigate into that, you will be opening a Pandora's box. So if you allow them an entry into the investigation, that's exactly what I mean. Mr. Alvin Young said that there's only 4 people who are causing trouble. So he said that from the get-go that we're only talking about these 3 issues. So we'll just list the £4 million. Did that breach items 1, 2, and 3, and anything else is superfluous. So Mr. Zhao Hoding did not say include. He just said why, and hyphen, dash, and so on. So I don't think that's a big difference. It's just a matter of order. So we can scrap away. We can scrap it to include matters, to inquire into matters. Mr. Zhao Hoding, your 3rd round. It's your 2nd round. Thank you, Chairman. Well, I just want to emphasize that the drafting accurately reflects the contents of the petition. So that's why I said Mr. Lam Jiak Teng asked, where do they start? And I want to clarify, to investigate why the chief executive did not comply with Article 47 all the way, and whether the payments were taxable under the laws of Hong Kong. So that's the wording I was referring to. So I just want to clarify that. So, because I just want accuracy in our work. Yes, Mr. Junius Ho had already relinquished and said that we can include the 3 points. So we're now looking at whether we need to retain the phrase to inquire into matters, and we don't want any ambiguity. So some colleagues might want a wider scope, some want a narrow scope, but do we have anything new? If not, let's hope we can get to reach a consensus. I don't wish to put the matter to a vote. So let's hear from you. If it seems that the majority, Mr. Andrew Wan and Mr. Kenneth Leung, the petitioners, if they agree, then we can include the phrase to inquire into matters. So it seems that we have 2 versions. Mr. Zhao Hoding, his wording, and Mr. Junius Ho and his supplementary addition. So do we have any preference? who could yield or concede? Mr. Zhao Hoding has helpfully provided a draft terms of reference for us.
So far, Mr. Holden Chow and Mr. Junius Ho have prepared a draft, and if there are no other comments, we can then follow that draft to narrow the scope of the TOR. Mr. Holden Chow has prepared the draft. Mr. Junius Ho, do you think you can accept this draft, or do you think that your suggestion is better, that is to have weather and then with a colon?
Thank you. 有冇咩初步嘅？大家傾咗點啊？
So can we agree on this?
就唔大嘅信息。
There isn't much difference. It's just a different style.
我睇咗啊。
Salam Shakting, I've read Mr. Holden Chow's draft. It seems that, maybe my eyesight isn't very good. I don't see the word UGL, the Australian firm concerned, and the receipt of payments, because the way he has drafted it, it seems to suggest that we should inquire into all conflicts of interest involving CY Leung and receipts of all payments. Wouldn't the scope be too wide, Mr. Chow? Thank you, Mr. Lam Chak Ting, for raising this point, because the Secretariat's version is more accurate in the sense that it sets out the background. Mr. Holden Chow? Well, as I said in the pretext, this is in accordance with the petition submitted in LegCo in December 2016. And I think that we all know that we're referring to the UGL incident. I think that we should all be clear about that. But it should not be self-containing or self-inclusive when it comes to the TOR. There is no need to refer to anything else. Well, so I think we should adopt the opening prepared by the Secretariat. The only question is whether we should adopt colon dash as suggested by Mr. Junius Ho or Mr. Holden Chow's version. So, do you have any strong views on that? If not, I think Mr. Junius Ho's suggestion is somewhat a good option, that is to adopt the Secretariat's proposed COR, and we delete some wording and then we replace it with colon dash. I think this would be more appropriate. Dr. Priscilla Leung? Oh, if we have reached a consensus, then perhaps Chairman can read out the proper version after deletion of some words. And for the proposed name of the Select Committee, should we also make corresponding amendments? Should we just delete matters relating to? Well, let's take things step by step. Well, please just read it out. If there are no other views, then let me read out the proposed preliminary TOR drafted by the Secretariat with Mr. Junius Ho's suggested amendment accepted by Mr. Holden Chow. Let me read it out. The terms of reference is to inquire into Mr. Leung Chun-ying's signing of an agreement with the Australian firm UGL Limited in 2011, bracket, double quote, UGL agreement, end of quote, end of bracket, and his receipt of payments amounting to £4 million from UGL Limited, bracket, payments, end of bracket, in connection with the UGL agreement after assuming the office of Chief Executive, including, and then colon hyphen, that is without the word including, colon hyphen, whether he had complied with the declaration requirements under Article 47 of the Basic Law and the systems of declaration of interest by members of the Executive Council, whether the UGL agreement had given rise to any conflict of interest on the part of Mr. Leung as the Chief Executive, and whether the payments were taxable under the laws of Hong Kong. Full stop. Did I pronounce the word taxable in Chinese correctly? Right. Any questions? I think that there was no need to have a colon there. Just say whether he had complied with, and then the so on and so forth. I think this is really minor. Perhaps the Secretary can help us with that. Just tidy it up. I'm sorry, you're right. If we have the word whether, then there is no need to put in colon. Sorry, my mistake. Well, let's do it this way. Just to amend Mr. Jun's Ho's suggestion, instead of using colon hyphen, we should keep the words whether this and whether that. No need to read it once. All right, no need for me to make another mistake. Thank you. So that's it for the proposed TOR. For the proposed name of the Select Committee, Dr. Leung already made her comment. Any other views on the proposed name? Well, basically, Dr. Priscilla Leung's suggestion is to delete the words matters relating to. If there are no other suggestions, then all right, I'm going to read out the name. Select Committee to inquire into the agreement between Mr. Leung Chun-ying and the Australian firm UGL Limited. Well, I think it's just about the title, just the name. Sorry, your comment is? This is just the title of the Select Committee. We've already read out the TOR. This is just to delete the word relating to in Chinese and to keep the word Siyi in Chinese. And I think we can delete the word Leg in Chinese as well. Well, perhaps we can even delete the word matters, and that is Siyi in Chinese. Mr. Lam Chuk Ting? I won't say my Chinese is better, because you raised your hand. Well, I was putting up my hand while you said that. Now, for the Select Committee to inquire into the agreement, I think it's somewhat strange because we are inquiring into the issues arising from the agreement and not the agreement itself. Now, some members did not like the word relating to, and then we deleted it. But I think that we should keep the word Siyi in Chinese. Any other comments? Well, let me just read it. In Select Committee to inquire into the agreement between Mr. Leung Chun-ying and the Australian firm UGL Limited with the word Siyi in Chinese. Thank you. Let's look at the next item that we have to deal with, membership size. That is paper bracket 02 in relation to membership size, nomination, and election procedure. So let's first deal with the membership size. I remember at the House Committee we discussed the membership size, and there was somewhat a dispute. The matter was eventually voted on. As for the membership size of the Select Committee, itself, I think that you still have different ideas. So comments from members, please, on membership size of the Select Committee. Mr. Holden Chow. Thank you. Chairman. Can we adopt the 11-member preparation committee as the basis? That is 11, with the size of 11. All right, any other views? Mr. Lam Chok Ting. I want to reiterate the point made at the House Committee last time. I think it would be more appropriate if we have a size of 13. We do not have any scientific objective indicator. I just believe that it would be the suitable size for more participation from members, because during SARS, basically it was a size of 11 and then 12, 13 and 15. Only one select committee had 11 members. We had 2 committees with 12 and then 3 with 13. Any other views, Mr. Wong Kok King? And I agree with Mr. Lam Chok Ting, the tall guy. It's not backed by science anyway, but I think that since C.Y. Leung has indicated that he would not be seeking for another term, so he's going to quit. Why the need to increase the size? Why don't we adopt the same membership size as we have now to save the argument? Any other views from members? We don't even have a target, really, Mr. Andrew Wan. I don't think that's the purpose of setting up a select committee. Mr. Andrew Wan. Now, after hearing from Mr. Wong Kok Kin, it suddenly occurred to me the following. I think that I've been confused by all the minor disputes. If Mr. Wong Kok Kin's logic is right, we can just dissolve this committee. Well, I've actually met C.Y. Leung a number of times. I have not I do not have any grudges with C.Y. Leung. I think the focus is on the 3 major issues set out in the TOR, whether he has not been complying with the requirements, and if so, he should be accountable to the public. I agree that we do not have an established criterion. Well, but the fact is, last time a few members would like to join and they were unable to do so. And if in the past we have had select committees with a size of 13, 15, whatever, then why can't we have 13? Because if we have one member who wishes to join but is otherwise unable to do so, we should rethink. Well, we should also consider the mix of political parties in this council, and we should also maintain efficient operation of the select committee. I think these are the points that we need to consider. Any other views? Mr. Junius Ho speaking for the first time on this issue. Well, basically, I support that if we have too many members, it may not be effective and efficient. We need to be efficient. That's also, I think, 11 is the right size. And also, I'd like to be as simple as possible so that we can deal with the issues more expeditiously. If we have too many members, there may be too many views. So I think we need to be precise and concise. That's why, in the very first place, I said that we need to have a main theme and side themes. So I support the size of 11. Well, please, Mr. Junius Ho, give us more of your witty remarks to humor us. Dr. Priscilla Leung. If you've ever participated in the work of select committees before, I don't know whether you are going to attend subsequent meetings and make comments, because there may be, if there are too many members, it may not be up to you to ask questions.
So the meetings become unwieldy. The chairman won't allow repetitive questions, and you've missed a couple meetings. Your colleague, it would be hard for your colleague to follow up. So if you're really interested, you wish to investigate or ask questions, then we need sufficient time to follow up. This is more efficient, and committee members would also find it more meaningful. So I think 11 is appropriate. I don't think we need to add more. So allow me to add that according to past experience, from our experience, any select committee, if we have a lot of Q&A, it's like similar to a court setting. When there are a lot of people, as Ms. Priscilla Young said, there is a problem with time management, and you cannot expect to follow the proceedings on and off. You cannot do that. You have to sit through the whole hearing. Mr. Alvin Lowe, Chairman. Well, according to that line of reasoning, 11 is too much. Why don't we just use 7 or 5 as the size of the member? Well, I want to highlight the logic. We might find that the PAC, Public Accounts Committee, has too large a membership. Should they be only 5? So, if all the arguments mentioned just now could be established, then why do we only have one select committee with a membership of 11? So people who are interested, they would attend all the meetings there. We don't need to accommodate, ask for questioning time, and cut the foot to match the shoe. So I see that if the establishment camp, if their reasoning stands, then should we reduce the membership size to 7? We have Mr. Kenneth Leung, who has experience in select committees and is also an experienced legislator. Let's hear from him. In my experience, 7 is a good number. You cannot skip the hearings. You have to attend each meeting. You have to read all the documents. And if you really want to be efficient, I think it should be 7. But if you want to open up the proceedings for members who are interested, or some people might not have the experience, it might be their first term as a legislator, we might want to open up the membership to 13. I think this select committee experience is needed. So I don't have any problem with 7, 11, or 13. You could use these numbers to buy a Mark 6 lottery. Mr. Lam Chok Ting. Chairman, I'd like to respond to Mr. Wong Kok Kin. He said that CY is not seeking a second term, and we can rush through the job. Well, it seems that Mr. Wong Kok Kin has an assumption that the purpose of this select committee is to stop him from his second term. I want to tell you and the public that's not the case. This select committee is to discover the facts, and it's not just whether there was misconduct on Mr. C.Y. Leung's part. We also want to see whether there was a problem with our system, and we also want to ensure that we have a graft-free system. So we should not link Mr. C.Y. Leung's running or not running a second term to our work. I just want to clarify that with Mr. Wong Kok Kin. Well, as a lot of members said just now, there is no scientific basis for the size of membership. We've heard the different viewpoints. It seems that, as Mr. Leung Kai-cheng said, he's fine with a 7, 11, or 13, and he can use that in the next Mark 6 lottery. So, if you don't have any strong views, well, ultimately we might need to take a vote if there's a big gap. But, it seems that 11, it is sufficiently large enough for members to gain experience, and it also allows one member from each political party to attend, and it seems that 13 is a bit too much according to our past experience. And so even in overseas jurisdictions, they would have one representative from each party to attend these meetings. So if you've worked as a solicitor, a lawyer, or a prosecutor, so a few minutes is not enough unless you ask questions without expecting an answer in the 7 minutes. So if you do want a reasonable proceeding, then I think we could start with a membership size of 11. If we don't have strong objections, let's start with 11. Okay, you can raise your views if you want. So even though the numbers 7, 11, 13 have been bandied, it seems that we have a bigger discrepancy on the figures 11 and 13. So let's put it let's see a show of hands on 11 and 13. So those in favor of 11, please raise your hands. Do we need to identify? Well, we have 6 colleagues who agree with 11. What about 13? Four colleagues in favor of 13. So let's start with 11. Okay, thank you for your cooperation. Okay. Okay. In House Committee, how do we nominate members to the Select Committee? The Secretariat has listed the procedure. If there are no strong objections, I suggest that you adopt this, and we don't need further discussion. Any views, Mr. Junior Solo? Well, I'm a new legislator, so I wasn't able to attend on the last occasion. I think this committee is quite important, and we do have chairman in this important role. So we do need. Do we need a deputy chairman? The suggestion is already in the paper. We can deal with that on the next occasion. If there are no other questions, then we'll adopt the Secretariat's proposal. We also need to confirm that we adopt paragraph 7 of document 02. Okay, we need to reflect it in the record. Okay, if there's no other objection, then we'll agree on adopting that. The final question is meeting dates. My understanding is that tomorrow is the first House Committee and we won't have enough time. So the next date, if the Secretariat can summarize our views, then on the 13th we can submit our report back to the House Committee, and on the 20th we can put the vote on the membership of the committee. If there's any postponement because of the Chinese New Year, then we would have to reconvene on the 3rd of February before we can elect members to the committee, select committee. So ideally we could submit our report to the House Committee on the 13th, if not then the 20th. Well, since we're on the topic, so I'd like to tell the Chairman or the Secretariat that we would like to have a full attendance. So let's ask members' availability, because in the past on Layman incident, we would ask in advance members' availability and schedule. So I'd like to bring that up. So let's identify which dates are most convenient for members. Legal advisor, any other questions? If not, thank you everybody.